are, and because we have a lot to pack in today, we'll go ahead and get started. I'm Prudence Beidler-Carr, the director at the American Bar Association Center on Children and the Law, and it's an honor to invite you all here today to learn a little bit about the Administration for Children and Families' recent release of a notice of proposed rulemaking on foster care legal representation. We're going to go into a lot more details about the what we'll refer to regularly as the NPRM, the Notice of Proposed Rulemaking. But I was asked at the outset to just orient everyone who's calling in to a little bit of the basics of what an NPRM is before we launch into the details of the specifics of the contents for today. And I have the sort of exciting opportunity to share that I have been on the other side of NPRMs before. I used to work in the federal government and have reviewed a lot of public comments before and can share how invaluable the process is from the perspective of those working in government. So an NPRM is something that the federal government, through a federal agency, issues to alert the public about a federal rule that they plan to issue. And in this case, the federal government has indicated that they are planning to issue a rule on supporting, providing financial support through Title IV-E for foster care legal representation. And we'll talk about the specifics of that in just a minute. But every time that a federal agency issues a rule, they have to go through a process beforehand where they tell you what they plan to issue and they invite public comment. And there's sort of three categories of how that public comment can be grouped. One is public comment, which we hope many of you on this call are planning to do, which is to support the rule and to say, you know, this will have a positive impact in these areas, and we support the federal government moving forward with this rule. The second category is to oppose a rule and to indicate why the rule will be problematic. We hope that most of you on this call are not planning to do that, but we welcome questions if anyone has them on that piece of it. And then the third is to seek clarification. And I think that'll be the bulk of today's conversation about areas where there are opportunities to seek a little bit of clarification before the rule is finalized so that it can be implemented as quickly and smoothly as possible once it becomes final. And with that, I will pass it to my fellow presenters who have a bit of a slideshow and PowerPoint to move forward.
Thank you so much, Prudence. My name is Jay Raman. I'm a colleague of Prudence at the ABA, the Associate Director of Legal Representation Projects, and also a member of the Family Justice Initiative, and proud to work with my colleagues here, Amelia, Hillary, Allison, Leslie, and that you'll be hearing all of them, and they'll be presenting themselves as they join in. And I really appreciate and love already in the chat everyone who's introducing themselves. So please continue to do that. We really appreciate to know who's here and continue the a really expressive chat. We love it. And please feel free to ask questions in the chat or in the Q&A. If you do in the Q&A, I think we can track it better. And if we don't get to your questions, then we can email you after the webinar. So yes, the webinar will be recorded and materials will be available to those who attended and also on the websites, both ABA and FJI. So hopefully that will answer all those types of questions. So we are going to share, as I do that and try to multitask, share a PowerPoint just to keep us on track more for our efforts. And then, like I said, we really encourage the questions. We want to make sure everyone feels good about the NPRM, what to do, how to support it, how to submit comments, what this all means for our legal representation world, both pre and post petition, and what's been happening in the community as we've been doing that. So let me start. Okay. Here we go. Okay, so I'm actually going to pull in my colleague Allison, who's going to take us through some of the elements of this process.
Thanks, Jay. Good afternoon, everyone. I'm Allison Green with the National Association of Counsel for Children. Why don't we just dive into what's going on here? On September 27th, there was an announcement from the U.S. Children's Bureau. You might have gotten an email link or even watched it live. They announced a package of 3 reforms to the U.S. foster care system. These 3 elements are not legally linked or technically linked in any way, But they were announced the same day because the administration is really putting them forward as a package that is both meaningful and symbolic of their philosophical values and the shifts they're trying to make in the foster care system. All three are changes or proposed changes to regulation, to the CFR. So these are not statutes we're talking about. We're not in the how a bill becomes a law process in Congress. We're in the executive rulemaking function. The three are, first, finalization of the kinship licensing regulation. So the first announcement was that on September 27th, they had finalized new rules that will allow states to have a different and hopefully more flexible set of licensing standards for kin. This is great news. We really encourage you to read up on the new rule, which is now final, and talk to your states to make sure they're implementing it. The second rule is a proposed rule. So like Prudence said, that before finalizing a rule, the federal government has to give notice, has to go through the rulemaking process. So this one is called Safe and Affirming Placements, and it really proposes to create new systems to provide safety and safe and affirming placements for LGBTQ youth. This is a proposed rule. It is open for public comment currently. Comments are due November 27th. It is not the topic of today's webinar, but it is also important, and I encourage you all to take a look at it. And the third proposed rule is why we are all here today. It is the legal representation notice of proposed rulemaking. So to be clear, the announcement on September 27th had three parts. Part one was kinship, and it was announcing that the rule is now final. This is now the law of the land. Parts 2 and 3 are proposals. Both are now open for public comment until November 27th. Next slide. So what's the process on this notice of proposed rulemaking for legal representation funding? Well, we're going to be encouraging all of you to submit comment. We're going to talk about how you can do that later today. All of that will be closed on November 27th. It's a hard deadline, so there's no asking for extensions. Then the federal government will review the comments. There is no mandate and how fast or swiftly they must do that. We want them to do that swiftly because this new rule is generally great and we want to see it implemented, for the field. But there is no, certain timeline or prescriptive timeline that they have to follow. I can tell you with the kinship rule that was recently finalized, it took them about 3 months. But I think that was quite fast, in my opinion. We also have other things, that are at play, like potential government shutdowns and an election in 2024. So there are some externalities that might be hopefully motivating urgency to get this done. Once the finalized rule comes out, which will likely be in 2024, hopefully sooner rather than later, Congress will then have 60 days to weigh in if it wants to on this. We don't think it needs to or should, but that will add an extra 60 days to the timeline before the rule becomes final in the Federal Register and ready for you all to take to the states and get moving. Next slide. So what's the big picture here? If you can just hit enter, Jay. The big picture, why is the government doing this? One, because high quality legal representation makes a difference. And this is just another recognition of the great work that many of you have been doing for years, that when children, parents, tribes, when everyone is well represented, the whole system functions better. We've seen this recognition growing over the last few years. We have more research that bears it out. We have some new funding. And so that's the big picture here. This is really finally the federal government acknowledging that lawyers and high quality legal rep are an integral part of both preventing the need for foster care to begin with, and then helping foster care cases run more smoothly and quickly and efficiently, and to get better outcomes than they're currently getting. Next slide. Oh, and then just to add, a big emphasis here is that this is bipartisan. What the rule change is doing was originally put forth under the prior administration, is now being codified under the Biden administration. And so it is bipartisan. And I share that because when you take this to your states, I think it's a really important point to emphasize that everyone agrees that this helps states get the outcomes they want. And right now, it is up to us in the next 14 days to make sure that the Department of Health and Human Services hears support for the rule loud and clear from the field. So what does the proposed rule do? It really does two things. First, it codifies funding that has been flowing since about 2019. And then it says, okay, we want to really double down on this and expand it even further. So it codifies part of funding and expands the funding. What does it codify? You may remember or have read emails or announcements that in 2019, the Children's Bureau changed its interpretation within the Child Welfare Policy Manual to permit Title IV-E funding to flow for children's representation and parents' representation in dependency cases. This was great. We have a lot of states that have done uptake on this. Hopefully some of them are the attendees on this webinar. Those are the funds that you may recall require working with the 4E agency to get those agreements in place. So if you are a law firm or nonprofit legal services provider, you can't just apply to the federal government to get that matching funds. You need to develop a partnership with your state agency. And that has been happening. When this change was originally made in 2019, it was done in the least formal way possible by the executive branch. And what is happening in this rulemaking is all they're saying is, let's keep doing this and make it more formal and more real and hopefully memorialize it for years to come for the field. That funding includes coverage for independent legal representation of children and parents, as well as multidisciplinary models, peer partners, social workers that help lawyers in their representation, as well as overhead costs, paralegals and investigators. That's the codification. Next slide shows the expansion portion. Oh, sorry. These are the states just quickly. This is a very rough map that shows some states that have used the funding so far since 2019. Big caveat on this map is that it's old. It's based on survey data that's a year old, and that if a state got a green designation, even if only maybe part of the state was doing this, piloting the funds in a particular county or city. So we need to update the map, but we did want to show you that the trend, although initially it took a little bit to get wheels off the ground to get this moving, the trend is towards more and more utilization of the funds. And I'll turn it back to Jay.
Thanks, Allison. We really hope we're covering just the foundation of understanding, which Allison did so beautifully. And we've been sort of doing this presentation or going to different tours and sites on just the importance of this rule. And just to emphasize some things that Allison and I have talked about or have come up during these webinars or Q&A is why is this really important? It's a rule, it's a regulation, even though it's not a statute. I mean, this actually really governs the way funding goes into the state. And it has created such incredible projects in prevention that we'll hear now from the different programs throughout the country. And even in places where you're not drawing 4E, and we have invited programs that may not be drawing down 4E exactly and doing the prevention work. The hope is once this rule is passed or codified in the way that Allison has described, that will inspire and support programs to actually draw down 4E, similarly to what has been happening since 2019 post-petition. So again, just to note, as that map suggested, it's been a great uptick of drawing down 4E funding. It has improved legal representation post-petition. It's improved raises. It's improved including social workers and multidisciplinary programs. And just to note, there are 11 states that have drawn down 4E funding for pre-petition. And several examples will be described now as we kind of explore what can you actually do once this rule or what is the work look like. So I'll stop for take a second now to sort of reach out to Leslie and Hillary who've joined us to describe what is pre-petition prevention work look like in your state and your program? I see Leslie, and also the value of multidisciplinary. So I'll start with you, Leslie.
So I think Hillary was going to go first, actually.
or
so
Hillary.
I'm going to pass it to her.
Sure.
Thank you.
Hi, everyone. My name is Hillary Cushions. I am a co-founder and currently the Chief Program Officer at Dependency Advocacy Center in Santa Clara County, California. We represent parents and youth in post-petition dependency cases and parents in pre-petition cases using an interdisciplinary legal services model where we have attorneys, social workers, and parent mentors with lived experience. We started in the pre-petition space with a program that about 7 years ago. And in that program, there was a tiny piece of it that did prevention work, and that has expanded over the years. And then in the summer of 2021, we started our first exclusive pre-petition program using that both programs use that same interdisciplinary model. And one of the components of both of those programs is providing limited scope representation, peer support, and ongoing case management to parents who are at risk of having their children removed, who have had some kind of CPS contact perhaps, but where a petition has not yet been filed. And we have served hundreds of folks in these programs, and it has been really powerful program. I will note that both of our programs are currently county funded and they're multi-year contracts. And so whenever the contracts are up for renewal, we get a little bit nervous. And we are very much looking forward to having 4E funds to be able to ultimately sustain, expand these programs so that we can have a really reliable, sustainable source of funding. I want to just quickly highlight a case that I think illustrates the importance of pre-petition work in the broader mission of advocating for children and families. Emma, I'll call her, a mother was had a case in another county. Her child was removed, her infant was removed. She was struggling with substance use disorder. The case ultimately got transferred to Santa Clara County, and the court dismissed the petition, and the local CPS here for a brief period of time offered voluntary services, informal services to that mother. The mother and the child went to a residential family treatment program where she could be with her daughter. And that mother was also referred to our program, one of our prevention programs, First Call for Families. Mom did really well. Emma did really well in that program. And ultimately, though, was discharged from that program. Emma and her daughter moved to her mother-in-law's home, the grandmother of the baby. And our first call team was still involved with the mom at that time. And Emma was really struggling with her substance use disorder and just was really clear that she had had a lot of trauma in her life and wasn't ready to re-engage in drug treatment services and didn't feel like she could really take good care of her daughter at the time. And so she made the decision to have grandma take care of the baby. And with the support of the First Call team, the attorney prepared a caregiver affidavit so that grandma was fully prepared to take care of the baby and did so. And mom left the home, and she was gone for a couple months. And then she came back, much to the surprise. I think some were surprised, but came back to that home, re-engaged with the First Call team, and was very clear that she was ready to engage in services, to focus on her recovery, and to be a full-time parent to her daughter again. And it made all the difference, quite frankly. And now she has custody, she has her child full-time, they're living on their own. She's working, she's in recovery, she's doing great. And I think this story really highlights the importance of pre-petition work. I don't have a crystal ball, but I can pretty safely say that if the court had not dismissed the petition and this case had stayed under the court's jurisdiction, we would most probably be looking at termination of parental rights given the timelines. But in this pre-petition space, And with the support of the first call team, this interdisciplinary team, Emma was really able to determine her own destiny and her daughter's destiny. She was the one who had agency to say, Grandma needs to take care of, my child while I can't right now. And then when she came back, she was ready and willing and fully able to take care of her child. And so I am very much in support, of funding this work. I think it's really critical to the advocacy we do on behalf of families and children.
Hillary, you can see, people are loving your story and just so thrilled. I just want to highlight, and if you don't mind taking a second, just all the elements that you described in that case. So there was a lot of family, custody, grandparent. Can you talk about how that you can see or hope that this rule or the work would extend to these types of cases going forward, or expanding the pre-petition work that you're doing?
Yeah, I think that there are lots of cases like this where, if families come under the jurisdiction of the court, and with the timelines involved and with the significant issues that families face, like substance use, mental health issues, domestic violence issues, that it takes a very different direction oftentimes. And if families can get the support they need outside of the courtroom, right, outside of the court's jurisdiction, if they can get the support of a peer mentor, if they can get the support of a social worker and an attorney, all working under that umbrella for advocating for that family and making their own decisions, in really believing that they are their own best expert in deciding what is best, with the supports in place and with being able to access services, then I think it's a win-win, and so there are lots of families that we see that are in need of these services. And while our first call team is incredible, and I'm so proud of the work that they've done, there is a lot more to do. There are a lot of families that we haven't yet reached, or don't have the capacity to reach right now. But with the expanded funding, we certainly could. So, and that's the hope.
Thanks, Hillary. Leslie?
Great, thank you. So I'm also going to talk a little. So I'm Leslie Heimov. I almost forgot to introduce myself. The Executive Director at Children's Law Center of California. We represent all of the children and young adults in the foster care system in Los Angeles, Sacramento, and Placer County, all in California, which gives us a client base of about 24,000 young people. And I'm also one of the founders of the Family Justice Initiative, and continue to serve on its leadership team. So I'm going to talk about our pre-petition work and also a little bit about multidisciplinary for the next couple of minutes. So similar to Hillary, we have a pre-filing initiative. We have two pre-filing initiatives, actually, and both are funded primarily. Ours are funded primarily through private fundraising, philanthropy, and grant making, because they are not currently claimable under our state contracts or through the support of federal authority, which is similarly why we are excited about this potential expansion. So our two programs, the first one serves current foster youth who are expectant or parenting. So I'm sure many of you have had the experience of a child that you represent as a teen or young adult becomes pregnant. And we know from the data across the country that those young people are at much greater risk than similarly situated peers of having their children enter the foster care system, of being separated, of losing their parental rights, etc. So in an effort to break that cycle of generational family separation, we created a program a little over 2 years ago, where anytime one of our teen clients becomes expectant, moms or dads, we provide them with a parent support case manager and an attorney. The parent support case manager works with them throughout the pregnancy if they're still pregnant, or as soon as we get the case, if they're coming to us already as a young parent, to provide them with support and services and coaching regarding how they're going to interact with the child welfare agency should they become subject of an investigation, which unfortunately they so often are, because they're already under surveillance as a young person in foster care. The attorney also, of course, provides legal services and one of the most important things we are finding, or most effective things, is our ability to be with the youth during any investigation, help them prepare for what that might look like if a social worker comes to their delivery room or comes to their home after the baby's born or before the baby's born, how to field those questions, and how to field that what is often an exceptionally stressful interaction. And not surprisingly, many young people are triggered by these experiences, and they're young. So some of it really is about just providing them with guidance and coaching about how to make the interaction not become explosive. And that often results in an investigation being closed. And the department closes their case, and we will continue to provide support until the young person is feeling confident and stable in their situation with their baby. In the 2 years and a few months that we've had this program, we have had 85% of the babies served through this program stay with their young parents, which is quite remarkable. We were hoping for 50% success rate based on data around the number of young people that are separated from their babies when they themselves are in foster care. And of the other 15%, almost all of them are either with a relative or the other parent. So close to 100% of prevention of a child entering foster care placement, of a baby entering foster care placement. So that work has been extremely rewarding. And I will tell a quick story from one of those cases. We had a young mom with a fairly large family. She herself, actually, I was mixing up my stories, sorry. We have a second project that I'm going to tell you about first, called the Family Support and Advocacy Center. That project provides the same type of services with an additional overlay of any auxiliary civil legal services that are necessary. And that program serves adults who were former foster youth. So they could be any age, they could be 20, 25, 30, 40, but they have some history as a child in foster care themselves, and now are at risk of losing their own children to the foster care system. That program, which we call FSAC, has had similar successes. It's a much newer program. We've served about 40 families, and none of them have had a child welfare case filed against them. And now my story. Sometimes it can be so simple, is what we're learning, and it's just that support. So we had a young mom. She had 5 children, was a former foster youth herself, and was living in very substandard housing. Her landlord was completely non-responsive to serious problems with the physical condition of the apartment complex. The area that was supposed to be the yard was filled with broken glass and bottles and car parts and all sorts of dangerous things. And she did not have the capacity to clean it herself, of course. There was similarly a staircase that had nails sticking out of it. So all of these things provided really significant hazards for her small children. And her landlord was completely non-responsive, and she was very worried that one of her kids would get hurt and then potentially, find themselves subject to an investigation. And our advocacy really amounted to advocating with the landlord and then securing the services of a handyman that was willing to come in and do the work at a very reduced rate, and negotiating that. So it was simple, but something that really changed the trajectory for this family and this housing situation that they were living under. So the second thing I'm going to talk about is multidisciplinary. We have been fortunate in California to have the original 4E program in place. We were an early adopter, so we have been drawing down funds for 4 years, and we are able to use those funds to expand our multidisciplinary practice. One of the interesting things that California did was they required that any entity that wanted to receive the 4E matching funds had to adopt some sort of program improvement based on the Family Justice Initiative attributes of high quality legal representation. So many of us did choose multidisciplinary as an expansion or improvement to our practices. And at CLC, because of our size, we are very fortunate to have a wide array of multidisciplinary team members, including social workers, peer advocates, TAY resource specialists, crossover specialists, a mental health team, folks that specialize in serving expectant and parenting youth, and more. And we recognize that because of our size, we are able to bring in a lot more specialization than a smaller entity might. But we have colleagues around the state that added a social worker, hired 2 peer advocates, hired 2 parent partners. So there are many ways to bring multidisciplinary to your practice. regardless of size. Bringing in folks as consultants if you don't have the capacity for a full-time position, or partnering with other organizations to develop a collective. And what I can say across the board is that by adding that multidisciplinary layer to our work or expanding it, all of us across California are finding a greatly increased capacity to connect with clients, to engage, to meet them where they're at, to help them navigate the system, with the goal of either staying out, or if they are in, getting out quickly and happily and in a health for their family to be healthy. Last thing I will share just is some data. In the past 4 years, the entries into foster care in California have dropped from 25,000 per year in 2019 to 19,000 as of about 6 months ago. And we can't say that it's 100% because of the 4E funding, but we know that our own caseloads are going down, and that is improving our ability to serve and helping cases to get through the system, as I said, more quickly, or not enter based on some of the pre-filing work. So just a host of great opportunities for those that are currently drawing down and want to expand, or those who are not yet taking advantage of the match and are looking for ways to improve their practice with this federal support.
Thank you, Leslie. Just briefly add, and then we're going to pull in Amelia, which her organization draws down 4E, post-petition, and the work that she's done. But just to emphasize the types of work, you heard from Hillary and Leslie, all various forms of what this work can look like, pre-petition prevention. I just wanted to cite and reference Emily Taylor Cook, who's heading the prevention work national efforts through her mentoring with Vivek and Melissa at Emory Law School, Melissa Carter, Vivek Sankaran, which really started this work years ago before even the codification of the work. And many models and programs have been based on their work in Michigan and now in Emory. And Emily has been kind enough to share stats and data points, research, where we're always asked, like, well, does this make a difference? If we're doing preventive work, will children remain out of foster care? Is that an outcome we're trying to achieve? And so just to note that generally, yes, I mean, nationally, and the data and research shows that foster care and the current foster system is traumatic to children and families. It's not an outcome that we're hoping to achieve, and there needs to be changes to the foster system. So with that said, with the research and data and unpacking the trauma and the poor outcomes that happen after removal, we've also learned that most of the involvement and issues that pull families into the foster system is connected to poverty, or coded as neglect, right? And then if we're trying to tackle poverty issues, what we've found that these prevention programs, providing legal representation early on, pre-petition to these families, as described by Hillary and Leslie, has prevented the entry into the foster system, lessened these traumatic outcomes to both children and parents. And so some of the other organizations, and we'll have this information available to you so you can directly reach out to them, is that we know that First Clinic in Washington State, since 2019, has tracked more than 300 of their cases, and 84% has not resulted in petition filing. The Family Defense Team at the Bronx Defenders also have been doing pre-petition work, and they have avoided filings in 68%. We also have learned that in Oregon, the Youth Rights and Justice Program, the Family Defense Project, has seen a 40% reduction in the rate of removals, and are believing that is connected to pre-petition. And personally, for me, living in New Jersey and starting pre-petition work at Legal Services of New Jersey, and just speaking to the director of that program today, Sylvia, there has been over 500 cases, that's parent assigned cases. So think about the thousands of children that have not entered into foster care, and none have resulted in a removal. And just to note, what are these programs doing? What are the types of work? We just heard from Leslie and Hillary. It is extensive. It could be eviction prevention, domestic violence, guardianship, custody cases, representing kin in the kinship navigator. It could be power of attorneys. It could be appealing truancy actions, IEP issues, disability, SSI, immigration. It's really compared and related to what your program looks like and what is available in your office, what's capable, what you need to do to provide prevention. So there's just so many types of programs available there that can be grown, progressed by what your desired and what your jurisdiction is permitted. So we want you to really dream big, access the resources you've heard here. We're all available. Our information will be in the PowerPoint and available online as well. But don't be frightened by hearing really, established programs, honestly, that we've described now. There's been smaller programs that have been sole practitioner, social worker who is interested in registry appeals, and the appealing registry findings for parents has been able to present those parents access to better housing, appealing credit issues, right? Accessing employment opportunities based on registry, because they're no longer on the registry and they can actually get employment and be able to provide for their family. So there's just various opportunities. And we hope, based on the way this rule is written and described and the work that's out there, that the comments will support additional work. So I'm excited now to reach out to Amelia, who we'll just kind of discuss briefly, Amelia, about what the fears and obstacles were in your experience and your understanding with drawing down 4E funds. Like, how do I work with my agency? Is this possible? Is this going to be difficult? I don't want to share my client information with the agency. So Amelia, take it away.
Thank you. I'm Amelia Watson. I'm with the Washington State Office of Public Defense Parents Representation Program. I'm also part of the leadership team for the Family Justice Initiative. And we in Washington State were, like Leslie and her program, we were an early adopter of the 4E agreements. We started drawing down funds in 2019. I think figuring out a space to feel comfortable negotiating with the agency can sometimes be complicated for parents' attorneys, and I feel like we need to kind of acknowledge those fears and also understand that the purpose of this funding is actually to support us all having access to more robust representation for our clients. And so back when we learned about this funding, it was an opportunity for us to reach out with our legislative leaders and just inform them to make sure that they knew that the intent of 4E funds was to not supplant current funding, but to kind of expand the profile. We have had multidisciplinary representation for quite a while in Washington State. And so we had experience with our legislators through that. And just they were really helpful in helping to clarify that when they were providing additional funding for us through our legislative program, that the intent of that was really for us to collaborate with our state agency to assure that we could get some 4E drawdown funds related to that. So our first year, when we got that additional funding, it was actually an expansion of salaries for contractors within our program to bring them closer to having parity with the state agency. And from that led to us having some pretty robust conversations around 4E agreements. Our 4E agreements talk about confidentiality and the needs to comply with the rules of professional conduct. And I feel like every year we kind of learn something new as we get another 4E agreement with the state agency under our belt. Our latest 4E agreement references one of the rules that you can actually get additional funding at a higher drawdown rate instead of the normal 50%. For some trainings, you can get a drawdown at 75%. So we've been able to kind of go back to the agency, work through it. The first year is always the hardest when you're maybe figuring out who you need to be talking to at the state agency, but our legislature was really helpful for that. And we're really excited to go back to working with the state agency with the potential of adding in pre-filing representation to that. I feel like every year it's an opportunity for us to have a better program in our state. And I'll link some of our latest agreements in the chat, but we're all here to support folks that are starting out this process new in their areas. It's possible and it's attainable.
Amelia, I just wanted to ask, were there raises or other like unique things with 4E funding that might be helpful for this audience to know?
Yeah, so again, when we went back for our first initial ask, there were actually raises associated with our contractors as a result of that 4E ask. We got a pretty substantial raise. I think it was in the 15 to 20% range back in 2019 for our contractors.
Great. And so again, I know there might be individuals on this call saying, wait, raises, and that's not the purpose, and is this directly, but as we've done data and research, so many of our attorneys, social workers, and parent peers are heavily underpaid, barely paid, are assigned. And this is critical. This is critical to invest in the work in legal representation. And again, Amelia State and her office is a model for that. And thank you for raising that. So again, thinking about how can we be creative, and this is now going to be still available. Oh yes.
Jay, can I add on the topic of raises? Compensation in general. Similarly, a lot of us around California, we were able to increase compensation as a result of the funding, but there was a direct connection. And I think you were starting to get to this, around retention, and retention relates to high quality representation. If your workforce is constantly turning over, you don't develop the depth and breadth of experience and expertise that's necessary to provide the best representation. So we really viewed compensation and caseloads as directly connected to quality representation and not tangential in any way at all, but really critically important if we want people to stick to the work and develop and relationships. Like, our clients need to have relationships with their attorneys. We're not transactional, right? And so that was, and it was persuasive to our legislature and to our funding, the Judicial Council for us. So I think that those arguments are actually relatively easy to make, and they tend to land well.
And I will say that our organization has used 4E funds specifically for retention, higher salaries, and lower caseloads, and it's made a difference. All of those are tied together, right? In order to have manageable caseloads and a somewhat of a work-life balance, right? That's really helpful. And this is hard work. And so smaller caseloads and higher salaries are certainly helpful in the retention space.
Absolutely. Deeper quality work is so significant. And thank you for tying that even stronger for this group. So just for the last few minutes, and then we'll spend time on questions. I can see there have been questions about the tribal representation. To emphasize and stress, yes, these rules are extended to tribal representation in state court proceedings, kinship care, legal representation, and then, as we've been spending time, pre-petition civil legal aid. Here are resources that will be available on several of our websites here who are representing, that gives a summary of the rule and the template and next steps. The actual rule itself is available, and it will be in the PowerPoint. At this point, I'm actually going to stop sharing and ask Allison to join back to kind of review next steps and actually how to comment and what the template that has been produced and collaborated by this group on.
Thank you, Jay. Let me just do this correctly. Okay. All right. I think that works. Can you all see my screen? So now that you've heard a little bit about our enthusiasm, regarding the rule, its codification about what it was already doing, providing funding for children's and parents' legal representation, and the proposed expansion to kin, tribal representation in state court proceedings, and the important preventive legal advocacy that my co-panelists talked about, you may be wondering, how can I support this, and what does the federal government need to know? We have designed a template for you to comment. We encourage you to use this as a template And we're going to walk through it now, and you're going to see the basics that we want to outline, as well as areas for you to tailor it to describe your own programs and work. So this is a Google document. You'll have the link to it. At the top are simply instructions for how to do a submission if you've never done a rulemaking submission before. It is shockingly easy compared to so many electronic systems that I know befuddle me. You can do it in one of two ways. You simply email the document to the email address listed, being sure to use the precise subject line that is, you can just copy and paste it for you, or there is a portal to upload it. And after you do that, you will get a confirmation email saying that it has been received. If you have questions as you're going through this, if you don't know what you want to say, please reach out to Jay or myself or our colleague Jenny Kempner at the Youth Law Center. We'd be happy to talk to you. What should the template say, or what does it say? We really wanted to start with positivity, because overall, although you'll see we have a few requests and clarifications that are coming, our main emphasis here is we want the federal government to hear loud and clear that this rule needs to be finalized. So I encourage folks to comment and highlight areas that may impact your work, or questions you might have, or areas that, that you may want the federal government to weigh in on after you read the proposed rule in its entirety. But I encourage you to not lose the forest for the trees, so to speak, and make sure that whatever you decide to include, that the overarching tenor of your comment is applause, positivity, thank you for recognizing this important work, let's get this done. And so we've given you some template language you can do. You can either insert where we have in yellow now, like talk about how you're using 4E in your jurisdiction. Talk about how you could use 4E for the clients you're serving to do preventative legal advocacy. Or if you don't want to talk about your work, you can use our sample paragraph, which is right here, where we just have summarized the research about what high quality legal representation does. Next, we get into two areas where we're requesting a little bit more. One is a request to clarify the definition of independent legal representation. So this is the exact term that the federal government is looking to put into the Federal Register. And they invite comment from the field on how that should be defined. The rule also proposes that states should be permitted to create this definition, but it provides a floor. It says at minimum, this means that there should be no conflicts of interests, that one party should not be paying for another party's legal representation. Well, we read through their proposed floor and minimum language, and we did feel, and we heard a lot of consensus in various meetings over the last month, that we need to tell them to fine-tune this a little bit more. Specifically, in many, many places, it's typical for one party to pay for another's legal representation. That's more typical under a public interest model, right? Like in indigent defense, it's very common for a criminal defendant to not pay their own public defender. And so we asked for that language to be excluded. But we also, most importantly, wanted to be very, very clear that the Title IV agency, and by that I mean the child welfare agency in your jurisdiction, does not get to decide what the practice of law is or looks like. That they probably don't even want that to make that decision, because that is properly under the jurisdiction of your state bar association, ethical opinions, and state rules of professional responsibility. So our language here is to remind the federal government that a social service agency cannot and should not be regulating what attorney practice is or defining what attorney practice is. And instead, we offer them some alternative language that will that they can incorporate into the rules. So we would like for folks to include that. And next, we just have a little highlighted yellow section where you can say, like, why is this important to your jurisdiction? Why does this need to be super, super clear? Second, we're asking the Children's Bureau to affirm the full array of types of legal representation that are eligible here. So you heard us talk through the different buckets, but as you read the rule, you'll see, well, what about this? What about that? And we just want to get this down pat. And so the proposed language here kind of walks through every step of the process and asks the feds, please confirm all of these are eligible. This includes preventive legal representation for a child or parent or a kinship caregiver, both to do all of that great civil legal aid work that Jay mentioned, like public benefits, preventing eviction, custody orders, things like that, but also representation in the actual CPS investigation, that pre-petition advocacy if a family is being investigated by the hotline, so that a parent has an attorney to consult with about their rights. Then after the preventative legal step, we're asking for confirmation that post-petition legal representation will continue to be covered for children, for parents, and now the addition of for intervening tribes. From the very, very beginning of cases, even though, in some places, sometimes attorneys are not even appointed as the petition is filed. That needs to change. We want to make sure that attorneys can be appointed as soon as a petition is filed, and let it go all the way through the end of a case, through the appeal. And that clients have access to all of the great civil legal aid that Jay mentioned, again, even if a case is filed, because we know that addressing all of those ancillary legal needs can help expedite a reunification and get kids home faster. And then lastly, we've added a kind of as a separate category, just to intentionally call out the needs of older youth in extended foster care and confirming that they too are covered under this. So we ask, for you to include this list of examples, include any others that you might have questions about. And then finally, we are asking the Children's Bureau to once again tell states that their expectation is that as this federal funding flows, that it is used to enhance the quality of legal representation. So Leslie mentioned in California, they said all of these funds have to go towards some quality measure. We get worried when we heard about states that were considering, oh, well, we're going to take these federal funds and then we can just move our other state funds elsewhere and make it all equal. That is not the intent of the rule. That is not what the prior administration wanted when they released this rule in the Child Welfare Policy Manual. That is not what the current administration wants. We're asking them to reiterate that in the language. Unfortunately, because of kind of like principles of federalism, they can't bind states not to do that in the rule, but they can reiterate their expectation over and over again, and we're asking them to do that here. So that is the template. It is short and sweet. And again, comment is due November 27th.
Thank you so much, Allison. So at this point, we're just going to try our best to answer questions for the last few minutes. And so I think they've been answered in real time, as my kids say, in real life, while we're going through this webinar. But the few that are remaining, Vanita had a question. I see Allison's typing, but I think it's a great question about what if you overall agree with the rule, but oppose a part. So I'll open it up to our panelists here if there's a reaction to that, and maybe address clarifying. I see Amelia or Allison if you want to take that first.
I mean, if you support some and oppose some, you are welcome to share that. I would encourage you to think strategically about what you want. Many of us in the call are lawyers. Like, think about, again, like the forest and the trees. If you oppose a really small part, is it worth bringing up because you don't want to risk, slowing down this whole process? Or is it really important? Is it some major red flag for you or your state that needs to be changed? Then include it. I would also, again, encourage, if you're weighing that and trying to figure out, is this worth mentioning? Are other states dealing with this? Could I get on the same page as another state or jurisdiction that's having the same problem? I'd encourage you to reach out to Jay and myself, and we can help talk it through and maybe just brainstorm how to word it. And so it's hard to answer the question, but there's no limitation to how long your comment is or what the content is. It's just more a strategic decision.
The only thing I'll piggyback on, Allison, because I think that's a really good response, is when you're thinking about what you oppose, if you oppose language in the actual proposed rule, that is a little bit different than just wanting to weigh in, because I think there's been a lot of discussion about things that people have questions about in the background section, where there's a lot of language, there's a lot of words, right? And so just be really, really direct about whether you're challenging language that you see in the proposed rule itself, because that's going to be firm, right? Once the rule is final, that's the language that's in the rule. Whereas like all the stuff in the background, that can evolve over time with guidance and with information memoranda and stuff like that. So that's kind of one of the distinctions that I think is important, with sort of figuring out if you're opposed to the rule language or the background.
Just to add, I mean, this is a group of lawyers. We all had different places. Wait, do we want to emphasize that? How do we lift up that language? I know Prudence and I have spent time at the ABA, even thinking about the overall overarching point of this, right? This is a upstream measure, right? Pre-petition. We hope that we're giving legal representation to families as described, but we also want to recommend and assert that even if attorneys fail at these cases, which we do, we may not prevent that eviction, we may not receive that domestic violence order, that doesn't equate to a valid reason to separate that child from their family. And so there's been a lot of work and history with ACF and the Children's Bureau that we know that they know that, but this rule, as described, doesn't have the same context and history that we've seen in other provisions that they've issued, right? So we're spending time emphasizing that. We want to lift that up in our internal comments. There could be debate about what is independent legal representation, what's kin representation. There is places here that you may absolutely say, wait, I take issue. Is that the best language? So again, as Prudence Allison said, we're holding on the words clarify, emphasize, lift up, distinguish, and again, taking a gamble, absolutely. And we have to be strategic and think through. None of us here submit that we will be able to protect what exactly happens, but the hope is that kind of sharing our thoughts and questions and spending time together in this way will lend itself to sort of landing at the right language to sort of promote the ultimate goal to support funding for this work, but not do any harm. Absolutely not. So I hope that goes to your question. I see there's some funding questions. Yes, please, Leslie.
I was going to add, there's a couple questions. There's one question about relationship with the agency, and there's some other questions about how the funding gets to legal services providers. So I wanted to kind of put those two together. In the 4E agency, in air quotes, is typically your child welfare agency. In some places it's at the state level. Most places I think it's at the state level, and some it's at the county level. And similarly, a tribe can have that type of relationship. So for many of us, what has to happen once there's a desire to take advantage of the 4A matching funds is the state agency has to amend their state plan and have a new contract with the federal government that explains that they're going to take advantage of the match, and then they develop all their processes around it. And so that takes directly into like, what if you have a bad relationship with your agency? And there are places. So what has to happen is you do have to have that discussion. There has to be a conversation. But what I think those of us that are successful in having our states take advantage of this opportunity is just to talk about it from a business perspective. It's not about who's going to win or lose in court. It's about fairness and justice and ensuring that every party has high quality representation. I mean, the argument that I would make to my local entity is it's better for you, agency, when you have well-trained lawyers and lawyers that don't know what they're doing, or when you have lawyers with reasonable caseloads so they can actually pay attention to their work and understand the nuances of their cases. And similarly, very few state governments want to leave federal money on the table. So when you're just talking about dollars and cents to say to your state or your county, you're going to leave federal money on the table, why would we do that? If we're bringing resources into our state that is better for our families and better for our communities. And I think that most entities can rise above whatever differences they might have on individual cases or policies to look at it from the perspective of the well-being of your jurisdiction. and that increased resources are good for your jurisdiction, regardless of which side you sit on in a particular contested matter, or how you interact on the ground with regard to individual clients. There was also a question early on in the chat about the match, and did want to clarify that there does have to be state dollars that are put up as the original match. So there does have to be some sort of state funding. It can be a new budget allocation, or it can be an existing budget allocation that then grows because it takes advantage of the federal match.
Thanks, Leslie. We are at 5. We do hope to be able to email or have these questions answered in some format, so we're saving the chat and the Q&A. And I will hand it over to Amelia to sort of close this out, and thanks everyone.
Thanks, Jay. I just wanted to respond so that folks saw in the chat the question about can 4A agreements include things like expert services, and yes, it can. These can be very expansive agreements. I want to make sure folks know that the Family Justice Initiative has a website that talks through 4A agreement funding more and includes some samples, and we'll definitely send you out some of the latest and greatest. And really go and support getting these 4A agreements. They're incredibly important, and we're really excited about this opportunity.
Thanks, everyone. Take care.
Thank you. Thanks, everybody.